All right, I'm going to go ahead and get started since it's 2 o'clock now. My name is Amelia Friedman, and I am a staff attorney with CILA. We thank you all very much for being with us this afternoon for our webinar with NILA on litigation for unaccompanied children, updates in foundational cases. This is part of an ongoing series that we've been hosting with them, and the prior versions are also available on CILA's website. As the starting point, again, for those of you who may have missed it, my name is Amelia and I'm a staff attorney with CILA. We encourage you to introduce yourselves using the chat function. You can send a message to everyone with your name and the organization. I'm going to go over a couple of housekeeping matters just to get us started. First of all, we will be using the Q&A function for questions for this webinar, and we have set aside some time for questions to be given to the panelists. And so if you have any questions, please submit them in writing using that, and then I will raise them with them at the end of the webinar. This is going to be a 90 minutes webinar, and it has been approved for CLE credit by the State Bar of Texas. We will be circulating a survey for CLE credit that you can use to fill out if you would like to request it, either in Texas or in another jurisdiction. And that will be sent in the chat at the end of the webinar and also circulated via email and a follow-up to the participants. We will also be circulating a survey for feedback for the webinar, which we at CILA greatly appreciate if you're able to fill out. We take the feedback very seriously, and we really appreciate it when people give us their feedback. And again, that will be sent in the chat and also sent via email afterwards. You should have hopefully received these slides in the handouts in PDF form that were circulated this morning. That was sent to all of the registrants. If you registered late for some reason, though, that's okay too. I'll send them again as well in a follow-up email to the participants as well. I'd like to just go over and start with a little bit of an introduction and background about CILA, which stands for the Children's Immigration Law Academy, and we are a project of the ABA, the American Bar Association. We're based in Houston, Texas, but we're nationwide. And this slide goes over some of the resources that we offer. We're an expert legal resource center and also a capacity building institution or organization. In addition to offering trainings like this one, which are often recorded and made available online, we also have a number of written resources on our website that we offer free to everyone. We host a series of working groups, both in Texas and nationwide, and they're done virtually, so you can participate nationwide as well. And those are on a variety of topics related to children's immigration law, from asylum law to special immigrant juvenile status. And at the end of this webinar, we'll have some QR codes, and they'll also be in the slides we circulate. If you're interested in signing up for those, you can use those as well. CILA also provides technical assistance on children's immigration cases, and you can submit your request to us through the website. And we have a number of pro bono initiatives, including a platform that hosts cases from some of the organizations that might be available to take. We are very pleased today to be joined by Trina Real Muto, the Executive Director of NILA, and Chris Record, a Special Project Advisor with NILA. And I'm going to hand it over to Trina briefly to talk a little bit more about NILA.
Thanks, Amelia, and hi, everyone. Thank you for joining us today. I just want to briefly introduce NILA to those of you who may not know about it. And apologies if you have attended the series before and have heard my spiel. I promise to make it quick. We're a relatively new immigrant rights organization focusing on immigrant justice through the courts, and we do that through our core programmatic work. Part of that work consists of impact and transparency litigation, which is just transparency, is just a fancy word for FOIA litigation. And I'm going to talk a little bit about some cases on NILA's impact docket later in this presentation, so I won't dwell on that. We also have a co-counseling program that is designed for new attorneys who are entering federal court for the first time or one of the first times. And even for more seasoned attorneys who are filing a new type of federal court case, we team up with you and we do that case together. Because we believe that working together presents a stronger case, for the client, and hopefully will lead to some success in federal court. And then finally, we have a strategic assistance and pleading review program that is membership based, where we provide individualized one-to-one strategic assistance on cases for a year. And our members get priority for pleading review, which means we'll look at the federal court complaint or the motion to reopen or the appeal brief or whatever it is, and provide high-level comments and substantive comments on that draft and line edits oftentimes too. And then last but not least, especially in conjunction with CILA, I'll note that we have some practice materials on our website, which are also available on CILA's website, that consist of advisories as well as some template pleadings. And with that, I will turn it back over to Amelia.
Thank you, Trina. And I'll just talk a little bit more about our ongoing partnership between CILA and NILA. We at CILA are very lucky to have been partnering with NILA for a number of years. This partnership includes trainings like this one that are live and recorded and made available on CILA's website, as well as what Trina mentioned. There are some practice advisories and templates available online, in addition to some other written resources. And our technical assistance, we do offer it in partnership together, and you can submit technical assistance requests for your cases through CILA's website. This slide has a little bit more details about some of the prior trainings that we've done together that should be on the website as well, if you would like to go check them out. In addition, as I mentioned, what we're here today for, litigation for unaccompanied children, updates in foundational cases, is an ongoing series. So if you're interested in some of the prior cases that were talked about, you can find out about those online. And now I'm going to hand it back to Trina, who's going to get us started with some of the cases we're going to talk about today. Thank you.
Thank you. Okay, so our first case today is fairly simple in terms of the holding and complexity, but I think that it brings out a great point that newer practitioners may be less familiar with, which is sort of the distinction between removal proceedings and proceedings that happened in immigration court before April 1st, 1997, which were known as exclusion proceedings or deportation proceedings. In this case, matter of JLL, this is a precedent BIA decision in which the person filed a motion to reopen a 2004 exclusion order and attached, the basis of the motion was a change in law based on the Supreme Court's decisions in Nies, Chavez, and Pereira, and they attached an application for cancellation of removal. And their gist of the argument was the Supreme Court decisions came down. My client was in the United States for 10 years. My client is eligible for cancellation of removal based on this change of law. But the Board of Immigration Appeals sort of rejected that argument in its entirety. And the reason it did so, I think, goes back to this point about the difference between the types of proceedings. I'll start by sort of just mentioning, as many of you are probably familiar, that Nies, Chavez, and Pereira are recent Supreme Court decisions that sort of talk about what has to be in a notice to appear. Because those decisions are interpreting current INA section 239, which is the statutory provision of the Immigration and Nationality Act, which governs the initiation of removal proceedings. And that statute says that time and place information has to be on the notice to appear. So those two cases stand for the proposition that, like the statute says, the time and place information has to be on the notice to appear. And if it's not, it doesn't stop the clock for purposes of cancellation. And I'll talk a little bit, how Pereira and Nies, Chavez sort of have evolved into other arguments. The point here is that those decisions were interpreting the current statute. And significantly, different statutes and regulations govern removal proceedings different statutes and regulations govern deportation and exclusion proceedings. So basically, back in the day, before April 1st, 1997, before AEDPA and IRA, which were the two congressional acts that sort of amended the Immigration and Nationality Act significantly, there used to be two different sets of proceedings. One was called exclusion proceedings, and that was initiated by Form I-122. And that was for people who hadn't effected an entry into the United States. And those individuals were sort of charged with the grounds of inadmissibility and subject to basically the grounds of inadmissibility in INA section 212. The individuals who had effected an entry were placed in what was known as deportation proceedings. And deportation proceedings were initiated by an order to show cause. Now, importantly, the Immigration and Nationality Act was amended by Congress and changed. And so part of that change was to enact current INA section 239A, which has this provision requiring time and place information. But before that, the Immigration and Nationality Act didn't have that specific language in the statute. And so what the Board of Immigration Appeals did here is to say that Nez-Chavez and Pereira are not relevant. They are interpreting a statute that doesn't apply to someone who is in exclusion proceedings. And so therefore, this argument that the client is eligible for cancellation is sort of apples and oranges, because the statute that the Supreme Court was interpreting doesn't apply to removal to exclusion proceedings. Rather, it was former INA section 242 capital B that applied. And, the board also notes in this decision that its rationale is consistent with the Second Circuit's decision in Jang versus Garland. So people have tried to make this argument before. Second Circuit rejected it, and now we have the board rejecting it. And so one point is, if you're an immigration practitioner who's new and you're going through a case file for somebody who's been here for a while, and you see something like a form I-122 that's initiating exclusion proceedings, or an order to show cause, which was the document to initiate deportation proceedings, that should set off bells and whistles for you, because that means a different set of statutes and regulations may apply to that person's application. And I know some of the regulations in the current regulations today reference deportation exclusion proceedings, but it's a little more complicated than that. And so if you're not sure how that applies, one thing I would strongly recommend that you do is to seek out somebody who was practicing before, in the early 90s until the change in 1996. Just sort of ask them if you're missing something, if there's something relevant here. There's different forms of relief were available back then. So that's one point. And then the second point I'll make about this is a point that we are going to elaborate on in our next training this summer with CILA, which is talking about how the Supreme Court's decision in Nez-Chavez and Pereira has impacted some other arguments that pertain to the charging document. And most notable there is how the statute has been interpreted when applied to individuals seeking to rescind in absentia orders, based on the argument that the NTA is defective and therefore they didn't get proper notice. And I will just say that we'll detail all of that this summer, but that particular issue has been the subject of a lot of litigation in the circuit courts to date. And in fact, there are 4 currently pending cert petitions before the Supreme Court that raise the question of what is the proper interpretation of the rescission statute. Does a defective NTA mean that the person didn't get notice? And the government, some of those petitions have been filed by our side, people who want that interpretation, and some have been filed by the Solicitor General's office. And so in at least one case that was filed by somebody out of the Fifth Circuit, the government acquiesced, which means the government said, yes, we want Supreme Court to hear this question. And then the briefing deadlines for the other cases are coming up. I think the last one is May 15th. And so by the end of the Supreme Court's term in June, we should know whether or not cert was granted and whether or not we will see yet another Supreme Court decision interpreting what constitutes adequate notice in a removal proceeding. And so I will just put that on your radar, and happy to address questions through the CILA and NILA technical assistance program, as they come up. But I just think people should be aware that those rescission motions are likely going to ultimately be resolved by the Supreme Court. So with that, I will pass to Chris to address the next case.
Thank you, Trina, and good afternoon, everyone. I'm Chris Rickard, he, him. I'm a special projects advisor for NILA based in Brownsville, Texas. And we're very grateful for this partnership with CILA and all of you attending today. I'm going to speak about 3 asylum cases. The first one coming from the Third Circuit, Saban-Cach. This was an opinion released in January, and it addresses an indigenous Guatemalan claim of Cach Mayan ethnicity. And to quote the opinion, Cach Mayans stand out from the majority population because of their names, language, physical appearance, and dress. In his town, Mr. Saban and his family were the only Cach Mayans. These were withholding-only proceedings because of a rather complicated procedural history. In 2014, Mr. Saban fled Guatemala, and we'll get into why, and attempted to enter the US for the first time. This resulted in an expedited removal order, but as soon as he got back to Guatemala, he left again and tried a month later and was removed based on reinstatement. In 2015, his third attempt to enter was successful. And during this period, his entire family was suffering, including a rape of his 16-year-old sister. The family had fled, and only a younger brother was in hiding, still in Guatemala. And the core of his claim is that he was targeted by MS-13 from a very young age, as a child even, leading to cuts and bruises. It appeared that there was a recruitment element involved in the gang's attention to him and his family, and death threats were made. He testified that he was scared to report to the police, also that it would have been futile if he had. And what became central to the court's analysis in one respect was that he left for a community called San Pedro, 90 minutes away, but the gang pursued him there, even though there was no physical harm in the San Pedro incidents. When he came back to his family and his initial home, there were, however, recurring attacks, one of which led to serious injuries inflicted with a broken bottle, and Mr. Saban showed scars during his hearing. As I mentioned, these withholding-only proceedings were initiated in 2020 after Mr. Saban was encountered by authorities in New Jersey. He was found credible by the IJ, but his claims were denied on the merits. The IJ decision was affirmed by the BIA on 3 grounds, but as we'll see, the opinion really covers 4. And so I'll mention that the IJ, in denying on nexus, held that the particular social group involved wasn't sufficient to establish eligibility for asylum. And here's the quotation: "While the gang may have sought the respondent's race as being useful to their agenda, the gang only harmed him when he refused to succumb to those recruitment efforts." So the idea that the recruitment did not have a mixed motive in terms of singling out the race as it's mentioned, but really the indigenous ethnicity. And the 3 grounds that I mentioned the BIA affirmed on were past persecution, internal relocation, and cat relief. And the court reversed on all grounds. In terms of past persecution, and I think this case is very notable for applicability in other settings. It's not written narrowly, and we'll see that many of the holdings have application in a broader variety of situations. So in past persecution, the medical treatment is really the first element of the panel's opinion, and it was right on the panel's mind because it was the first question at oral argument. And this was why the agency held that there could have been more medical treatment sought. So the BIA speculated in the panel's opinion that after being stabbed with the broken bottle, Mr. Saban did not need sutures or surgeries or any further medical treatment. The panel said, without awareness of whether the medical services available covered such treatment. And the panel faulted the BIA for conflating not seeking treatment that may have been unavailable with not needing such attention. And the record showed that the hospital that was potentially available was far away from the village, although the distance wasn't specified. And here's the really broadly applicable passage. The opinion is cautioning the IJ and the BIA, and in other cases as well, against, quote, ethnocentric evaluations of petitioners' resources. Petitioners primarily come from countries in the poorest and most dangerous regions of the world. Any presumption that they enjoy the same kinds of resources as their adjudicators is short-sighted and unfair. The second aspect of past persecution that the panel reversed was an argumentation at the Third Circuit between the Petitioners' Council, which came from Seton Hall Law School Clinic, and the government about which line of precedent was more applicable. There was a recent case decided after the BIA opinion in this matter called Doe, and the government cited a case from 2021 as well called Thailand. And in Thailand, the injuries were not as grave, the panel held, as in Mr. Saban's case, and the attack was a sole attack, or called a one-off. However, the court emphasized that even a single incident can establish past persecution. So although there are severe injuries and multiple attacks here, that is not necessary to establish the level of past persecution. Particularly relevant for CILA, the Third Circuit addressed for the first time, it said, whether the age of the claimed past persecution, namely that Mr. Saban was a child at times, was relevant to the analysis. And it concluded that it was, even though the opinion says we need not provide a definitive answer here. Soon thereafter, a fairly definitive answer states that the BIA should have explicitly considered what effect, if any, these experiences had on Mr. Saban given his youth, as well as the impact of his family's suffering on his emotional or psychological harm. So that seems to be an invitation, certainly, to raise that in the Third Circuit and potentially get a 100% ironclad holding, as other circuits have applied to children. I mentioned that the BIA affirmed on 3 grounds, but the panel also decides the particular social group issue because it clearly disagreed with the agency's take on what the recruitment's intersection with indigenous ethnicity bearing was on asylum eligibility. And so they said Mr. Saban clearly established membership in a particular social group as an indigenous person in Guatemala. And I think the panel usefully points out the basis of the IJ's error, because Mr. Saban established membership in a particularized group as evidence from the gang's persecution of him for refusing recruitment that was attempted because he was of Cach Mayan indigenous ethnicity. So even though the recruitment was the goal, the agency didn't properly analyze why they were singled out, and that identity was immutable and socially distinct as required for the particular social group. For the second matter that the BIA did engage on, internal relocation, you'll recall that the San Pedro relocation, about 90 minutes away, was held by the agency to justify refusing asylum because of a safe possibility in Guatemala. Again, this really was something the panel thought misread the record. There was an expert report that, quote, it is exceedingly difficult for individuals, particularly indigenous individuals previously targeted by gangs, to move from the area in which they have grown up and find a safe, secure place to live. So that's very individualized in terms of its analysis. But also, as I mentioned, Mr. Saban's younger brother continued to need to hide in Guatemala. And another intervening opinion had been issued by the Third Circuit subsequent to the BIA's analysis here, called Nasimba in 2021, stating that we know of no authority that interprets, quote, safely relocate as a synonym for relocate, and we refuse the BIA's invitation to ignore that important condition. So it was more implicit in this opinion, but essentially the court also had to reject that because no physical harm took place in San Pedro, as opposed to the hometown of Mr. Saban, that was a mitigating factor. And finally, reversal also on the Convention Against Torture aspect of these proceedings. And here there is a precedent that the panel concludes the agency did not follow properly, called MIRI, but that's from 2017. And there are really two aspects to the CAT analysis. The first is that the mode of looking at what would happen in Guatemala if Mr. Saban were to return was not applied properly. Instead, there was almost a asylum or withholding type review of whether the harm that was already suffered constituted torture. That may be relevant, but it's not the entire inquiry. And then the objective evidence is very important, and we'll hear an echo of this in one of the other cases I'll discuss. The panel said was more than 1,000 pages. And what's really, I think, important, again, in a wider context, is that the panel didn't take at face value the agency's claim to have looked at, quote, the objective evidence. They wanted more than that. They wanted analysis and careful attention to it. And the second aspect is interesting in terms of the CAT reversal. On MIRI's second prong, as the panel puts it, instead of first evaluating all of the evidence to determine the government official's likely response, and then asking whether that response constitutes acquiescence, which is required for Convention Against Torture relief, the BIA looked to some of the evidence to determine whether it suggests the officials would acquiesce. And so that may seem quite a fine distinction, but the panel explains that it's very important to make those two determinations separately because of the standard of review. One is a factual finding, which the BIA would look at for clear error, but the application of the facts to the legal standard of acquiescence would be de novo. And so that merging is an error in itself. And the court concluded that the record would support a finding of acquiescence with the analysis of willful blindness, which many circuits have used to explain that the government doesn't have to volitionally acquiesce, but can, in situations like this, where there was no reaction to the 16-year-old sister's rape, even after the father complained, and no action taken against MS-13's abuse here, but also its power in the country. And so, just in conclusion, I do think that one practice idea that might come out of this is that when there are intervening decisions that are so relevant in the panel's view, it may be a prudent idea, and this may have happened in the case we don't know, to approach the government and ask at least for potential mediation or remand based on the precedents that may not have been available to the agency. And the other thing just to say is this, and again, it'll be a contrast to a case I'll discuss in a moment. The argument was 36 minutes, very thorough, praise for both sides. A record like this really is elucidated in terms of oral argument as well as the briefing. So I'll turn it back to Trina.
Thanks, Chris. I am going to go back to talking about a BIA decision. The decision that we'll discuss is matter of Duarte-Gonzalez, recently issued by the board and dealing with the issue of unlawful presence in that bar. As you may recall, there's a ground of inadmissibility under 212A9B, which makes a person inadmissible if for 3 years, if they've accrued less than a year of unlawful presence, and for 10 years, if they accrued a year or more of unlawful presence. And one thing for the grounds of admissibility, they are relevant to adjustment of status. So this individual was somebody who was admitted to the United States for a temporary period not to exceed 30 days. So the individual stays more than 30 days, almost a year, and then leaves the country. So there's about a year, over 1 year period of overstay. So during that overstay period, the person didn't have status and they were accruing unlawful status. So what happens afterwards is they then depart the country and shortly thereafter come back to the United States, again get admitted on non-immigrant status. I think it was a border crossing card. And then they stay in the United States and they don't depart. So in removal proceedings, the non-citizen conceded removability and applied for adjustment of status under 245A, which is showing that the person was admitted, and so it was adjusting under 245A. The IJ, however, said that he was inadmissible because he had accrued unlawful presence and failed to stay outside of the United States for the entire period, the 10-year period. So this person was subject to the 10-year bar. And also denied the person a waiver, which I'm not really going to get into, as sort of a side issue. But on appeal to the Board of Immigration Appeals, the BIA reversed the IJ's determination and concluded that the person didn't have to spend the relevant 10-year period outside of the United States. And what's interesting about this decision is the board sort of first starts by saying that their decision in matter of Duarte, which is a 2006 decision, sort of left this question open. And so they weren't sort of bound by Duarte, and it left the question open. And so the board's rationale here is, in a way, overly simplistic. They focus in on the plain language of the statute, and the statute talks about being unlawful, somebody who is unlawfully present in the United States, who again seeks admission within the period, the 10-year period. So focusing on the 10-year bar here. And the BIA says that seeking admission refers to seeking adjustment of status. And therefore, the plain language of the statute suggests that you don't have to leave the United States during the 10-year period. I should say, more than suggests, holds that you don't have to leave the United States during that 10-year period of admissibility. And the board kind of goes on just to say, and admissibility runs from the date of departure. So once you've accrued unlawful status and then you depart the United States, your period of inadmissibility begins to run. And this individual had overstayed for more than a year, so was subject to the 10-year bar. But the rationale here applies sort of with equal force to the 3-year bar. And so I think that, you know, to the extent that this board's decision might render one of your clients eligible for adjustment of status, it's important to raise the issue of eligibility, of newfound eligibility based on this decision as quickly as possible, and in the procedural, through the procedural mechanism that makes the most sense. So if you're before the immigration judge, you're going to want to raise that maybe in a filing, you know, before the hearing, especially if this individual might be eligible for adjustment as opposed to some other type of sort of more cumbersome type of proceeding. You'll want to get that on file. It could potentially be a motion to remand to consider the adjustment application if the case is on appeal before the BIA. And it could potentially be a motion to reopen if there's been a decision by the BIA in the case, or if it could be a motion to reopen if there was an IJ decision that was never appealed by BIA. And then, of course, to the extent that there is an issue, this issue comes up and the case is before the Court of Appeals on a petition for review, this is the kind of thing that you'd want to raise with opposing counsel in mediation, and you know, try to work something out in terms of reopening to pursue adjustment if you have a client that is affected by this decision. I know we have a lot more to cover, so I'm going to leave it at that for now. I'll turn it back to Chris.
Thank you. And I'm going to do two asylum cases next. The first one coming out of the Fifth Circuit early this year, and the name is Mohndamenang, a Cameroonian case, but this will set the tone for the discussion. The majority has a per curiam opinion and a concurrence in the judgment by Judge Graves don't even agree on the name. So the majority speaks of Arafat, which appears in the briefing apparently and in the opinion, but is at least sequentially first name. So in this case, as I mentioned, it's a Cameroonian English speaker who applied defensively for asylum in November 2019. He said in his testimony that he was arrested and tortured in prolonged detention in Cameroon, and also had participated in a peaceful protest where the military appeared and killed some demonstrators. There were two rounds of agency proceedings, one with an initial immigration judge who concluded that the testimony was too vague to be credible and also unsupported by corroboration. On appeal, however, the petitioner submitted several affidavits and secured a remand to a different IJ, but was proceeding pro se at that time. This time, the IJ again denied relief, but found the petitioner credible. The lack of corroboration, however, was not overcome. And I'll quote from the second IJ's opinion: none of the affiants actually have any personal knowledge of the events described in Arafat's testimony. Arafat provided no other evidence of any injuries he stated he suffers. So the BIA affirmance led to the petition for review, and this is also counseled by a law school clinic from University of Georgia. There's not, however, argument. It appears the panel called off the argument. And as I said, what resulted was per curiam majority and a concurrence in the judgment. The first important holding is on corroboration, and this analyzes matter of LAC, a BIA decision from 2015. And in short, matter of LAC requires notice and an opportunity to explain when corroboration is potentially going to be held against a respondent in immigration court. However, the majority here held that the BIA's procedures do not apply in this manner. And here's the distinction. The agency in this case, according to the majority of the Fifth Circuit, ruled based on the absence of corroboration as a whole, rather than, quote, specific corroborating evidence that is covered by LAC. And this is really where Judge Graves diverges and concurs only in the judgment, because he says the LAC procedures may still apply even if there are multiple pieces of missing evidence. So he doesn't find in LAC, and indeed, it's not clear that the BIA was contemplating this distinction, that the whole holistic absence of corroboration is treated differently. However, Judge Graves does identify a different scenario in LAC that is, quote, circumstances in which the absence of corroborating evidence may be so glaring that no explicit opportunity to explain its absence needs to be given. So that's clearly different from the quantum of corroboration as a whole versus specific in the majority's view, but still may allow a bypass of the LAC procedures. However, what Judge Graves then goes on to do in the concurrence in the judgment was say that the IJ here did give the petitioner multiple opportunities to explain why several parts of his story remained uncorroborated and his answers were insufficient. So even applying the LAC requirements, Judge Graves would deny the petition for review. The concurrence is only in the judgment, as I said. However, it doesn't independently address the issues I'm now going to discuss. So we only hear from the two judges in the majority about them. The majority did address the argument on the substance of corroboration, as well as the procedures under LAC. And the strange characterization of the IJ's determination that there was insufficient corroboration here by the majority is that it's, quote, highly discretionary. They may mean that there's a lot of latitude and the fact finder is the best place to assess it. But of course, discretionary is such a term of art these days that it stands out as an unusual word to use. However, the conclusion is fairly cursory, that while the affidavits, country and newspaper reports, independent corroboration make it possible that the petitioner suffered what he claimed to suffer, they're offering only circumstantial evidence as a whole. I think, again, just on the theme that oral argument can elucidate some parts of the record that are pretty important, the IJ had held here, and as I mentioned briefly at the start, that the petitioner provided no evidence of any injuries. However, the opinion recounts that at trial, he tried to show the IJ an injured foot, but the IJ stopped him, saying, "Stop, stop, stop." For the panel, it's unclear from the record whether the petitioner actually showed the IJ his injured foot or whether the IJ erred in stating that there was no evidence of injuries. So usually with that sort of inconclusive record evidence of such a potentially central aspect of the case, one would think a remand could be justified. However, the majority steps in and makes its own determination with reference to deference and substantial evidence, which really isn't the same as allowing the agency to decide things first and correctly, that without more, the fact of injury here cannot show that it was sustained in the alleged manner. Interesting comparison to other cases in which the agency's prerogatives are respected as the first mover in that sort of determination. Again, the majority, very cursory fashion, which might be helpful in limiting the applicability in future cases, but is undoubtedly disappointing in terms of its treatment of the CAT claim. There were three reasons the IJ gave for denying the CAT claim. One is not rising to the level of torture. The other is that the idea was that things had changed in Cameroon or did not indicate that Cameroon would torture the petitioner if returned. And the third one was corroboration again. And in other areas and circuits, credibility has really been held not to be permissible in the asylum and withholding context to then sweep over a CAT determination. But here, the panel does, I think, an analogous move, which is saying, we'll take the third corroboration problem, and the regulations, to be fair, under CAT also echo potential need for corroboration, but they say we don't need to look at the facts of the torture or the conditions in Cameroon because the corroboration is sufficient. One would think that if the other two reasons were shown to be clearly wrong, or the record apart from the testimony and the need for corroboration indicated potential CAT eligibility, that the agency should redo it, but the panel majority doesn't go there. And just as a few final thoughts, one procedural matter that's of interest here is that there was a year-long stay of removal motion pending. So the petitioner filed a motion to stay removal that was opposed in March 2022, but it wasn't decided until early 2023 because in September, the court ordered the motion assigned to the panel. So that's an interesting feature to keep an eye on the patterns of the Fifth Circuit in stay determinations, because that clearly was important for the petitioner to have that year, and it could have gone in the other direction and the stay be denied. I think also the deference point is very important on LAC. So here you've got essentially a federal court of appeals interpreting the BIA's precedential decision in a way that it appears the BIA may not have intended. Certainly in Judge Graves' view, is a different take on when notice and opportunity to be heard are required for corroborating evidence. So that is important in terms of Brand X or administrative law principles in general, because that doesn't freeze the agency's ability in future to clarify that LAC meant something different. So that's sort of rare holding based on court's understanding of an agency's own precedent, just to say that that argument should not necessarily prevent at the agency level continued use of LAC, even where the corroborating evidence that was demanded is not necessarily specific, but related to the whole claim in the distinction used by the majority. And finally, what we've been looking at in various contexts at NILA is increased potential use of motions to reconsider or motions to reopen because the federal courts may not, either on jurisdictional grounds or, as we see here, it appears potentially through impatience about remanding the injury issue or things that the agency may not have done properly in the first instance. That makes it all the more important to consider, and this may not have been available to the petitioner here operating pro se, but whether pointing out these errors is important before the agency in terms of a parallel strategy, or depending on how the Supreme Court rules in Santos-Zachariah, whether it is necessary to exhaust or present to the agency some of these things in the first instance. But I'll just move to my last case, which comes from the Ninth Circuit. And this is Trina's turn, so I'm going to hand it back.
Thanks, Chris. And sorry, I think the slide order got switched around a little bit from the material order. But that gives you a nice break before you start your next asylum claim recitation. So I am going to jump, as mentioned earlier, to two impact litigation cases that are on NILA's docket that I think that people who represent asylum seekers and TPS applicants may at least want to know about, have been filed, and factor that into their representation. So the first case is a case called Garcia-Perez versus USCIS, and it is about challenging USCIS and EOIR's policies around the asylum EAD clock. And as you all know, that is the clock that calculates the 180 days from when an asylum application is pending that opens up the window for eligibility for employment authorization. And there used to be a case on the books that sort of set forth some protocols that the agency had to follow around the asylum clock, and that was done through litigation, and the settlement in that case was called ABT, had expired. And so this is a new case that challenges a couple things, but notably it first and foremost challenges the fact that there is no sort of viable mechanism to get notice of adverse clock determinations and for advocates to challenge incorrect adverse clock determinations when they are made. And so this is a putative class action, which means it hasn't been certified, but it was filed as a national class action along with a motion for class certification. So that is sort of everybody who has a clock issue would be in that class if it's certified. But then we hone down and challenge sort of three specific policies. One is the problem of the clock not starting after a case has been remanded by the Court of Appeals or the BIA. The clock just, they weren't restarting the clock. The policy that a change of venue motion would be considered an applicant caused delay and stop the clock. And then finally, the policy that unaccompanied children were facing, where the clock would stop because they were in removal proceedings and the application for asylum was transferred to USCIS, or it was just filed with USCIS in the first instance, as is required by the statute, which requires that USCIS first adjudicate an unaccompanied child's asylum application, and they were just stopping the clock there and considering that an applicant caused delay. So this case, after it was filed along with a motion for class certification, quickly went into negotiations. Negotiations are confidential and they're ongoing, although we're cautiously optimistic that there may be progress to report. in the coming weeks and months. However, what I think has happened since the lawsuit was filed is that USCIS updated its notice, the link of which is on the slides and in the materials, to make clear that its policy is to restart the clock if a person wins remand from either the Court of Appeals to the BIA or from the BIA to an immigration judge. And so I wanted to make people aware of that change to the policy. It's been around since September, but we continue to find out from folks that they weren't aware of it. So that is why we are mentioning this case today. And I will move next to the next slide. I should have said the other case was filed by NILA and the Northwest Immigrants' Rights Project. The case I'm going to be talking about now was filed by NILA, the Northwest Immigrants' Rights Project, and the law firm of Kurzban, Tetzeli, Pratt. Maybe there's another name I'm forgetting. This case is about, again, about work authorization, but it is for seeking work authorization for TPS applicants. Case is called Mansour versus USCIS. And again, it is a putative class action, which means it hasn't been certified, but it has been filed as a nationwide class action. And it challenges USCIS's policy of not providing work employment authorization documentation to non-citizens who apply for temporary protected status and have basically prima facie the legit applications. And so the plain language of the TPS statute affords employment authorization documentation to people with prima facie like bona fide TPS applications. And that has not been happening. As many of you probably know, USCIS waits until the TPS application has been granted. And at that time, will approve an application for an EAD. Even though that EAD application has been pending, it oftentimes is filed at the same time as the TPS application. So we think that is wrong. The government has sought a temporary extension to respond to our class certification motion. We should be getting their response in the middle of this month. We also filed what's called a preliminary injunction seeking relief for our named plaintiffs, so that seeking that because they are TPS applicants, that the government immediately issue employment authorization to them. So stay tuned. We will share updates about this case and the other one with CILA, of course, and they'll also be posted on NORP's website and NILA's website. And with that, I will pass it back to Chris.
Thank you. And my final asylum case to discuss is from the Ninth Circuit, called Cristobal Antonio. The panel refers to the petitioner as Antonio, but likely should be Cristobal. She petitioned for review based on experiences in Guatemala of being perceived as a lesbian. In 2014, Rebecca Cristobal passed a credible fear interview based on her dressing in men's clothing. She was threatened with death by neighboring villagers and whipped by her uncles. This is key to the decision that she said to the asylum officer in terms of the credible fear notes: the people from your village and your family members, referring to her, are motivated to harm you, with at least one central reason being that they believe that you are a member of the particular social group that is lesbian women in Guatemala. And interestingly, and this is fairly rare, Ms. Cristobal did not testify at her individual hearing, but submitted a consistent declaration. And this elucidated that the police did not act on her reports. This was very much aware by the government that this was happening, but the record indicates that the village's mayor even was aligned with others' hostility toward her. In an interesting aspect of the case, she did come forward to complain with a justice of the peace in the San Pedro municipality of Guatemala. And it isn't clear from the record whether any action was taken in response, even though the complaint was referred to prosecuting authorities. At the same time, after the complaint, and this is in late 2013, the treatment worsened. Quote, members of the community waited for her at her place of work and attempted to lynch her. They demanded that she remove the men's clothing or else she was, quote, going to burn. The IJ made a positive credibility determination, but denied relief for several reasons that I'll go into because this is a streamlined case where the BIA affirmed without opinion. First, the IJ said that the abuse Ms. Cristobal suffered did not rise to persecution, also concluded on the professed particular social group that she could change her style of dress. So the characteristic is not immutable, and the proposed group was, in the IJ's view, quote, too amorphous. And this was very important to the case because Ms. Cristobal testified that she was not a lesbian. The IJ concluded there was no sexual orientation issue presented. So in the Ninth Circuit, some of the argumentation really was challenging for the petitioner's attorney. And I might just surface this to begin with because there was an issue in the case of government acquiescence or not. And this, by all accounts, wasn't in the petitioner's briefing. Nevertheless, fortunately, the panel agreed to decide it because A, it was exhausted, and B, the government had briefed it in the Ninth Circuit, and so wasn't prejudiced by the waiver, but of course could have gone in the other direction. However, and I generally don't single out the government attorneys because this was quite an exceptional situation. I think if anyone is interested in the oral argument, there are some quite damaging aspects to the way Oil argued this case. The first is more pedestrian, but the attorney clearly misrepresented the record in terms of the threats and the severity and frequency of them, and said, quote, I haven't read the record since last week. This was a Wednesday argument that didn't, it appears, hold much water with the panel. But even more alarmingly, in my opinion, he made an analogy when discussing whether this was truly an immutable characteristic. When the panel asked about the perception that Ms. Cristobal was a lesbian, the attorney brought up stating to the panel, I don't know if you're baseball fans, but you may remember that Mike Piazza of the New York Mets was at one point put in the rumor mill as being gay. What he did was have a press conference where he denied it and, quote, that solved the problem. So I don't think this helped the panel's perception of the government's opposition to this case. And what came out was a really important opinion. And to really get to the merits, one has to go to the concurrence because two members of the panel would not join Judge Sanchez, who wanted to really provide a roadmap for the BIA to see perceived sexual orientation as a protected ground, a particular social group, because there wasn't Ninth Circuit, or it appears to the panel BIA case law definitively holding that, but the panel applied the ordinary remand rule, so it's going back to the BIA. I think that's the only disappointment in the opinion from my perspective, however, because it's extremely strong on several counts. The first is really applying longstanding Ninth Circuit case law that threats alone can constitute past persecution, but here there was much more than threats. The escalation of the threats, the seriousness, and the confrontations that happened in this case are analogous in the panel's opinion to a case called Ruano from 2002. And here there were actual violent attacks, even though that wasn't necessary for the level of persecution needed for asylum. So the IJ is pretty quickly dispatched on that analysis. And the lack of physical harm, again, that's an echo of some of the other agency determinations in recent asylum cases that are being reversed. It's the persecutor's perspective, not the consequences that matter, the panel really stresses. The record doesn't reflect here the injuries Ms. Cristobal sustained, but This is very clear in the Ninth Circuit's law, and the panel emphasizes we do not require severe injuries to meet the serious harm prong of the past persecution analysis. And this is important in terms of guidance for the remand. The panel analytically says there was a clear error by the IJ and the agency about the self-identification as not being a lesbian defeating a particular social group because it involved only, quote, manner of dress. And this is a very careful opinion in terms of record references. The panel, and I won't go into it too much, but it's worth seeing just how clearly the panel concludes that the record wasn't properly analyzed by the IJ, that even though there were slightly shifting particular social groups proposed below by Ms. Cristobal, the core of it is sufficient to propose a social group of women in Guatemala that are perceived as lesbian. And again, the government acquiescence question, even though it was potentially waived, was remanded because the panel, in a way analogous to what I mentioned in the first case, didn't take at face value that the agency had looked at all the particular and objective evidence in the case about the potential acquiescence. It also said, and I think this is important, that the holdings about particular social group and the misperception by the agency of that nexus could bear on the analysis of governmental acquiescence, because if you're getting it wrong and saying that sexual orientation doesn't apply here, you're not really looking at the correct acquiescence issues. So the takeaways that I've touched on already are also supplemented, I think, by the fact that here the panel relied more than is usual on the asylum interview. If that's in the record and can help, even though she didn't testify and put in the declaration and some of the information was in the asylum interview, that is very central to how the panel decided the case. So very important to highlight all aspects of the record. And I do think that on remand and for other circuits that may not have confronted the question yet, one would expect the BIA to consider publishing an opinion on something that is analytically and also potentially applicable in many situations. There's some analogous Title VII type perception of a protected ground law that could be applicable here. But ultimately an important decision and a strong rejection of a line of analysis, both by the agency and I think an oral argument that didn't, I think, live up to the highest standards that one expects in these sort of cases. So I'll pass it back to Trina.
Thanks, Chris. I think Amelia is going to join us for some Q&A.
I am, yes. Thank you, Trina and Chris, so much for those are great presentations. We have received some questions in the chat, which we'll go over now. And if anyone still has any other questions, please feel free to submit them using the Q&A function. We'll try to get through as many as we can as possible. But looking at the ones we've received so far, I think we can start with these ones for Trina about some of the pending litigation you talked about. And the first one is, what is the timing for the Mansour case?
Oh, so thanks for that. So Mansour is the case about TPS applicants who should be eligible for, or we think should be eligible for employment authorization. The government's response to our class certification motion is due April 17th, and then we will file a reply in support of class certification. There's tentatively set a hearing on that motion in Seattle on April 28th. And then with respect to our request for preliminary injunction, which would give our named plaintiffs, the ones who need it, employment authorization. Right now, their response to that is due April 24th. We would file a reply and there'll be a hearing on May 5th. There may, the hearing is at the court's discretion. So it's noted for a hearing, doesn't necessarily mean the hearing is going to happen on that day. It could get postponed, it could get canceled and decided on the papers.
Great, thank you. And it looks like the other question, we also had one about Garcia Perez. And the question is, if someone has an EAD based on a defensive I-589, does the clerk restart after they file an affirmative application if their removal proceedings are dismissed, or can they renew as a normal C-8 renewal?
So for that question, I would ask the person to contact us through CILA offline. I don't know the answer off the top of my head and tried to get my co-counsel to provide an answer. So I think we'd want to look into that more. I would be remiss if I answered definitively without looking at the policy and the regs before I answered. So I don't know that off the top of my head. Sorry.
Okay, thank you. And that was an anonymous submission, but if the person is listening, you're welcome to submit the technical assistance request through the CILA website, or if you are having trouble navigating that, you should hopefully have my email from when I sent the materials, so you can follow it by email that way as well, and we'll try and connect you with NILA as well. We did also receive a question for Chris about the Saban-Cach, the asylum matter. And there's a couple there. I'll turn to those. So the first one was, has the PSG in Saban-Cach been accepted by other circuits?
A good question. There isn't citation in the opinion to other circuits. And of course, there's an intersection here between the indigenous ethnicity and the gang recruitment. So I would definitely recommend looking under both of those headings. But the panel didn't have the benefit of BIA analysis here, but really relied on its own precedent and a First Circuit precedent about social group. But this may be an important opinion in terms of age, gang recruitment, and indigenous ethnicity intersecting.
Thank you. And the other question about this case was, can you elaborate on whether you're aware of other circuits that have adopted child-friendly language to consider age when assessing asylum claims?
For sure. So there is a citation in Saban to the First Circuit's heightened standard. And I would also recommend a Fourth Circuit en banc opinion. I'm sure very familiar to CILA from 2021 that held that the age is crucial in looking at persecution claim, and that's called Portillo Flores.
And I would just pipe up with an oldie but goodie out of the Seventh Circuit, which was one of the first cases that we talked about when we started this series last year. In that case, I would probably really mispronounce the person's name, but it's Kolyavsky, K-H-O-L-Y-A-V-S-K-I-Y versus Mukasey is out of the Seventh Circuit, and it's 540 F3rd 555 from 2008, which stands for the same proposition that age is heavily bearing on the question of whether or not a child is persecuted.
Thank you. And Trina, we also had a couple of questions about the matter of JLL case. The first one was, does the holding and matter of JLL potentially extend to any other types of proceedings that we should be aware of? And I might ask the second one too, since they might be related, I'm not sure. But the second one was, it seems like matter of JLL is another way for the BIA to limit the influence of Nice, Chavez, and Pereira. Do you think that will have any influence on the overall landscape of cases related to defective notice issues, or is this a sufficiently distinct problem?
Yeah, I'm glad you asked those questions together, because I think my response is completely similar. Like, I don't think that the BIA got JLL wrong, because the petitioner there was trying to make an argument about what's required for an NTA for an individual who's not subject to the statute governing NTAs, but rather was subject to the predecessor statute, which didn't have the same language in it. And so, you know, the BIA can't stretch statutory interpretation about a statute with different language into the predecessor statute when that same language didn't exist. And so I think that is the importance to knowing what statute governs in the proceeding. And for removal proceedings, I think it's probably a lot simpler for folks. You open up the INA, and the INA has got all the statutory changes in it. But if you get a FOIA back and you have an order to show cause or a form I-22, you know that your client was previously in a different type of proceedings. And so then you want to look at what statutes and regs govern. So I don't think that this was a surprise decision, as the BIA itself mentioned. This was a decision that was consistent with what the Second Circuit had already said in response to the similar type of argument or the same argument. And so I don't think that this decision is sort of relevant or significant in any way to the issue that I was talking about that's going to go to the Supreme Court, which is whether a defective NTA in removal proceedings could be the basis of a motion to rescind an in absentia order. And that is because the in absentia statute talks about notice, and it references back to INA section 239A, which was the statute that the Supreme Court was interpreting. So, you know, that issue, I think, goes up to the Supreme Court. Regardless, the BIA has a precedent decision on that particular issue. Not surprisingly, it's not favorable, called Matter of La Parra, but that case originated in the First Circuit, and the First Circuit rejected the BIA's interpretation. The Ninth Circuit has rejected the BIA's interpretation. The Fifth Circuit sort of rejected it and walked it back. You know, the 11th Circuit has adopted it. There's different fact patterns for these cases, but they all sort of raise the same big picture general issue, like what constitutes sufficient notice or deficient notice for purposes of an innocent absentia motion to rescind. And so I think that is something that is going to go up to the Supreme Court. I'd be surprised if it didn't, when you have both sides saying, please resolve this issue, particularly when the government is saying to the Supreme Court, please resolve this issue. So we shall see. We'll know by the end of the term in June, most likely, whether or not it's going to go up.
Thank you. And switching back again to the asylum world, there was one more follow-up question for Chris about the Saban-Cach matter, and it was, for that case, for Saban-Cach, do you have any advice for how to argue that the BIA failed to review the evidence properly?
I think this has to be acknowledged to be a particularly probing panel analysis. You see many of the copious footnotes referring directly to pages of the record. Having said that, though, I think the mode of analysis is applicable elsewhere. Certainly, the level at which the agency has to specify that it examined the record is something important to argue. I know the other day, a colleague mentioned that the IJs at times simply list the exhibits and say, we've considered this. In this context, that would be analogous, in my opinion, to what wasn't accepted at face value, which is that the agency reviewed the objective evidence. I think another aspect of it, of course, this seems to have been particularly well argued, and there were resources to have an expert, et cetera. So the record itself was strong. But the other aspect that I think is interesting from a legal perspective is what exactly the error is in failing to consider all the evidence. There would be an administrative law error, and there'd also be one with potential constitutional dimensions in terms of the due process. The due process might need to show prejudice, and there may be presumptions that are different in those two contexts. They may overlap, but it certainly would be worth, in a particular circuit, looking at exactly how the court's precedent and analyzes a claim based on either the constitutional or the administrative law claim, or both.
Thank you. And the other one is related to the Fifth Circuit case, and I apologize in advance if I do not pronounce this name properly, but in Mohndamenang, the IJ stated that the affidavits were not sufficient corroborating evidence because no one was present at the beatings. What impact do you think this has on government gain claims, considering it's a common tactic to take the victims to an isolated area for such beatings? The Fifth Circuit seems to have sort of skirted around that aspect of the opinion by saying the IJ considered a lack of credibility as a whole rather than focusing on specific evidence.
It's an excellent point, and perhaps the cursory nature of the opinion is helpful in not going further as the IJ might have in terms of the personal observation that seemed to be required and doesn't, in my opinion, have a practical or legal justification. I do think that the conjunction of that with the refusal of the IJ or the court to grapple with whether the injuries were presented below really made this almost impossible for the petitioner. But what you mentioned is absolutely key. Why wouldn't it provide corroboration? And again, this has echoes in other areas of the law, be they alleged sexual assaults or other corroboration where someone can tell a witness, as it were, afterwards, who may not have seen the event, but is something that you would take to a jury or find relevant to the weight and persuasiveness of the case. So hopefully the fact that this is so abrupt and relies on LAC in what seems to be a unjustified way, at least heads off, as you say, skirts that larger issue.
And I think related to that, there was also a question of, are there other interpretations of the corroboration requirements in matter of LAC that would be more helpful to rely on from other circuits?
A great point. So I was able just to look at the Kurzban section on this. It's in page 1008 of the new edition. And in the Ninth Circuit, apparently LAC has been rejected as an unreasonable interpretation because it does not give an applicant the opportunity to be told what corroborative evidence would be expected and an opportunity to explain why it's not reasonably available. So the notice and opportunity to be heard that wasn't even adopted by the Fifth Circuit in this case has been held by the Ninth Circuit to be inadequate because the IJ, as I understand it, could say, well, you don't have corroboration without going further and specifying what it could or should be. And there are citations here to other circuits that have adopted LAC, but also used it to reverse. So maybe a three-level standard. There's the Ninth Circuit, there's LAC, and then the Fifth Circuit.
Thank you, Chris. And then switching gears a little bit, there was also a question for Trina related to a matter of Duarte-Gonzalez. And the question is, in matter of Duarte-Gonzalez, do you think the recent policy guidance from USCIS is a big factor in the outcome? Is there any risk that the policy guidance will change?
Well, I believe that the question is referring to footnote 3 of that decision. And the board mentions USCIS's policy guidance about how the person doesn't have to spend the time outside the country and says that its decision is consistent, the same as USCIS, which, it also says they're not bound by district court decisions and, they basically can think independently, but, oh, by the way, we're reaching the same conclusion as USCIS. So I thought that it's interesting because the board sort of points out when its interpretation is consistent with USCIS while not feeling like they are bound by that. And so they use it when it serves them to point that out. But because it's a favorable precedent and USCIS has the favorable precedent, I think that it is helpful when the immigration courts and USCIS have uniformity when it's in the non-citizen's favor.
Thank you. I believe we've addressed the questions that are in the Q&A so far. We have a couple more minutes. If anybody has any additional questions, please feel free to go ahead and submit them. I actually did have a question myself for Chris. You had mentioned that you had been doing some ongoing research related to motions to reconsider. And I was just curious if, based on that research and kind of what you had seen in this asylum case, if there had been any lessons learned or things like that that you thought might be worth sharing in addition to what you did. If not, no worries, but I was curious to hear you mention that as well.
For sure, and I welcome Trina's input also, because this has been a focus in terms of what was accepted by the Supreme Court for review this term in Santos Zachariah, the idea that the Fifth Circuit, and not alone, but certainly creating a circuit split, has held that individuals who want to raise something based on the BIA's own actions in a decision that have not been aired before the agency need to be raised for exhaustion purposes in a motion to reconsider. So the understanding that if the BIA introduces an error, that is something that can go to the circuit court was upended, because what the Fifth Circuit has held and some of the other courts have worked through with varying lines drawn of what type of error the BIA would introduce, puts added burden certainly on a pro se petitioner to understand what exhaustion means at the agency. So that was argued earlier, no decision yet, but it will have enormous implications, of course, if the motion to reconsider requirement is upheld, but also in this case, and I might invite Trina just to talk a bit about the history of NILA's involvement. There's the issue of whether exhaustion is jurisdictional or a claims processing rule.
Thanks, Chris. I will just mention what that first question presented was and let people know that we elaborate on that in an amicus brief we filed to the Supreme Court in this case, of Chris's help. And the question there is whether or not the exhaustion provision is a claim processing rule. And if it is, then it's subject to waiver, forfeiture, and equitable doctrines, or if it's a jurisdictional rule, which are rigid rules and you know, have to be adhered to, otherwise, like, you haven't exhausted and that's it. And so we argue, I think we have the better argument that it's a claim processing rule, and therefore, because the government didn't raise this issue before, it should be considered waived and the non-citizen shouldn't have to deal with it. But this concept of claim processing versus jurisdiction is something that I know a lot of folks have dealt with after Pereira, but it also comes up very much when you're trying to argue that a deadline is subject to tolling. Oftentimes, and the Supreme Court in a series of cases have looked at deadlines and statutory provisions and analyzed whether or not there's a clear statement that the rule is jurisdictional and therefore it can't be waived or subject to equitable doctrines, or if it's a claim processing rule. And so, yeah, there's a bunch of information in our amicus brief about that, and it's something that we're always trying to think creatively about when it comes to deadlines in the immigration context or other just sort of rules, whether or not there's an argument that, you know, it's not jurisdictional. And the fact that, you know, the government didn't raise it means they waived it, or if there's an equitable exception, like a gross miscarriage of justice, for example.
Thank you. And it looks like we did receive a couple more questions, so we'll try and get through these in the next 5 minutes as much as we can. But the first one is, by when are we expecting a decision from the Supreme Court on Singh v. Garland, whether an in absentia order of removal should be reopened if the respondent's NTA lacked the date time of hearing? I think this is a follow-up for you, Trina.
Sure. So Singh is the good decision out of the Ninth Circuit. There's two, Singh and Mendez-Colon, which stand for the proposition that a defective NTA, it means that you basically win your motion to rescind for lack of notice. The brief in opposition, which is being handled by the Stanford Clinic, is due May 15th in that case. And that is sort of the latest date of the petitions, of the 4 petitions that I mentioned that are pending. So what would happen after the brief in opposition is filed? So clearly they won, so they don't want this to go to the Supreme Court. Is the government may file their reply, but once the briefing on the cert petition is complete, what happens is it goes to conference at the Supreme Court, and basically the Supreme Court is hearing conferences every Friday until the close of the term, which is mid to end of June. And so after conference, if cert is granted, we will see an order from the Supreme Court granting cert or denying the cert petition. So I don't have a definitive answer. I just can say that it's definitely not going to be before the end of May, because the brief in opposition is only due in mid-May.
Thank you. And there was another follow-up for Chris as well, related to the Fifth Circuit case for Mohndamenang. Do you think the petitioner proceeding pro se before the IJ had any impact on how the circuit panel viewed the corroboration procedures?
It's a very good point. It certainly should have, because imagine seeing from the outside, be it within the US, observing the asylum system, or from another country, what happened in this case, right? The representation was extremely strong at the Fifth Circuit from the University of Georgia clinic, but the panel gave short shrift to any context, really, much less the pro se proceeding. But we don't know from the record that we don't have. The opinion doesn't specify whether the petitioner was counseled the first go round with the IJ, likely because these affidavits were put in and the remand was won from the BIA. And as you'll remember, the first IJ made an adverse credibility determination, the second didn't, but they both denied on corroboration. So you wonder if the legal resources that went in, at the first and third stages, as it were, would have won the case at the second stage, because that IJ found him credible, but again, found the materials put in that the BIA doesn't remand every day, as everyone knows, certainly got him back into immigration court. So there are rules, of course, in some circuits to take into account pro se status for various issues raised to the court, but it didn't have an effect here.
Thank you, Chris. And I think we have time to squeeze in one more question for Trina. And this one I think is about the pending litigation, and it's, what is the issue about or regarding the TPS's EAD, given their automatic expansion? Oh, Trina, I think you're on mute.
Sorry. Oh, sorry. I'm not sure if that's supposed to be automatic extension, because TPS gets extended. And so I welcome the opportunity to sort of clarify this. Our lawsuit is about first-time TPS applicants while they're waiting for their TPS application to be adjudicated. That's when we think that the government has the obligation to issue employment documentation, because that's what we believe the statute requires. Once you've submitted a prima facie valid TPS application, you're supposed to get those temporary benefits, which include employment authorization documentation. For people who have TPS, right, so the government grants, right now the practice is they grant the EAD when they grant the TPS. Those people can then extend, if the government extends the TPS program, they can extend TPS and will be able to keep their employment documentation. So our lawsuit, just to be super clear, is about people, the ability to work while a person is waiting for their TPS application to be adjudicated.
Thank you so much. And with that, I'm going to wrap us up. I believe that the surveys that I mentioned at the beginning for CILA and for the feedback have been shared in the chat, and I will also be circulating them via email as well. I will also leave you with a reminder that, as I mentioned at the beginning, that we do host a platform for pro bono cases at CILA, and we encourage you to share it with anybody that you work with who might be interested in taking a case. There's also a QR code for folks who might be interested in joining CILA's newsletter. And this last slide also has some additional information. If you would like to get more involved with CILA, we would love to see more of you. As I mentioned, there are working groups you can sign up with, monthly newsletters, technical assistance, and whatnot. But I would like to give a huge thank you to Chris and Trina for all the presentations today. As always, it's a great pleasure to work with you on these webinars. And with that, I think we will be concluding today. Thank you very much, everyone.